Well, hello to you. I'm Joe Ryan. Haven't made a video in a long time for you gentlemen, and perhaps there's a few ladies. I'm speaking to the serious students now. I have been aggressive and sarcastic with the historian cliques. We have the amateurs that hang around Sharpsburg. They live in the area. They work for the National Park Service. They're tour guides, generation after generation, and they have time on their hands, and they write books. Just absolute crap most of the time, although there are a couple of good arrangers that have written books worthwhile reading. John Hennessy, Mr. Kirk, two that come to mind. The rest of them, a waste of time, just pure historical fiction. Then you have the elite academics, Mr. Gallagher, Mr. McPherson, Mr. Gilzo, our dear departed Peter Carmichael. They have institutes. They put on seminars at different battlefield events. The Civil War Monitor magazine has about 35,000 subscribers. The Civil War Talk, which is, it's like The View. It has 30,000 or so subscribers. So that's about the market for the Civil War buff people that, old white men with their wives who have nothing else to do but go to Gettysburg and spend a couple of grand listening to Gary Gallagher pontificate about nonsense. So yeah, I've been pretty vocal over the last 40 years about the incredible sophomoric presentations these characters make about important events in our Civil War, and my concentration has always been on General Lee and the Army of Northern Virginia, and in particular his coming into field command in June of 1862 and taking those young Americans that made up his army to Antietam. So I've done this before in other ways, but I want to, in one place, at least for the historical record, give you the benefit of some 40 years of serious trial lawyer investigation into the facts of the case, for the purpose of showing you what the ultimate result has been. So that if I was in the trial court today with a jury in the box, making my opening statement as to this particular facet of the case, these are the facts that I have discovered in my investigation, and which I can feel confident presenting to the jury as the truth of the matter. Trial lawyers, unlike the guys from Sharpsburg and the academic elites, trial lawyers didn't have the luxury of manufacturing crap to feed to a jury and expect to get a verdict. Trial lawyers are advocates, and their character for truth is ultimately what brings them their verdict, because the jury is expecting the lawyers that are making these speeches in front of them to be lying through their teeth, trying to trick them and fool them into a verdict. And so the lawyer that can present himself as the honest one, as the one that brings them nothing but objective truth, that's the one they're going to rely upon in the end when they go into the jury room to decide their verdict. And to have that kind of credibility as an advocate, you cannot You get caught in a lie, it is instant death. It's like dagger in the chest. You'll bleed to death in an instant. You cannot lie. So what I present to you here are actual, objective, undisputable facts. I cannot tell you I cannot lay out the whole story as a mosaic without gaps. 175 years has passed since this event occurred, and I'm limited to what is available to me now as an objective record. So let's begin with this business about who wrote the Lost Order. There are other facets of the case that will take weeks of trial, which are not the subject of this video. How was the order lost? Not the subject of the video. How was the order found? Not the subject. All we can talk about today, in the few minutes that I want to present this, is what can we say as objective fact to identify the person who wrote the Lost Order. It's that simple. And to do that, we have to have our focus on the documents, the original documents that have been preserved for us through the benefit of the Library of Congress, the National Archives, and a variety of depositories in universities in the South, Virginia, North Carolina in particular. So, the first document in time that no one can dispute in the creation of Special Order 191, and which leads us to an effort to identify the writer of the document that actually ended up in the hands of George McClellan, is this this one-page document. This is the front, this is the back, called Special Order 191. This is it. This is the original Special Order 191 in its original form. And this document is in the hand of a guy named Arthur Pendleton Mason, a great-grandson of George Mason, who was raised in Alexandria, Virginia, inherited some property from his parents, sold it, and moved to Arkansas. When the war broke out, he joined a company of men in Arkansas, and he ended up in Missouri in a regiment. A cousin of his was Joseph Johnson's field headquarters adjutant, and he got Mason to Johnson's headquarters staff in about December of 1861. And Mason was with the Adjutant General's office in Richmond while Johnson's army was in that area, and he was identified in various documents as an assistant Adjutant General on General Samuel Cooper's staff. At the same time, Robert Chilton was in Texas. He was a paymaster in San Antonio when the war broke out. He came to Richmond and eventually obtained a commission as a colonel of cavalry in the Provisional Army, and he ended up with Mason on Adjutant General Cooper's staff. When Johnson ends up in Manassas, these two men are attached to his headquarters staff. On September 9, 1862, at Frederick, A.P. Mason wrote out this document. This is his handwriting. It's undisputable. Special Order 191 up here in the corner, 2 paragraphs. The document was signed by Robert Chilton over here. This document was then sent by courier, as all similar documents like this, to General Cooper in Richmond. And that's where the document remained until the war ended and it ended up in the hands of the United States War Department. And here it is, original 191. Now, at some point in time, we don't know when, we don't know, it could have been 10 seconds after he filled this out, 2 hours later, 2 days later, we do not know, but we do know that A.P. Mason copied the contents of this letter into Chilton's letter book. Now, the letter book exists, and it goes from about December of 1861 to December of 1862. It's a bound letter book. And it was Chilton's responsibility, with the assistance of his helper, Mr. Mason, to not only send the original orders, a copy of the original order written in the hand of Mason, to Cooper's office in Richmond, but to maintain a record of these special orders in his letter book while he was in the field with General Lee's headquarters staff. So at some point in time, Mason copied the first 2 paragraphs, which is the sole document here, into Chilton's letter book, which you see here in front of us. It's called 191. Now before, in the pages before this, there's a 190. The pages after this, there's a 192. Now, you'll notice that this has more than 2 paragraphs. It has 10. So at some point in time, after Mason wrote this out and it was sent, the other 7 paragraphs had to be written out in some form. And then later copied by Mason into the letter book, adding it on to the first 2 paragraphs. And that document original is this one. This is an original document. And it's called Special Order 190. But it's not the Special Order 190 that's in Chilton's letter book. Special Order 190 in Chilton's letter book, and with a similar standing free copy sent to Cooper, involves the transfer of several soldiers that are on sick leave. Now, the writer of this document, we can discover, is a clerk, an unknown clerk. The name is unknown. Who this person was is unknown, but he's a clerk in Lee's headquarters staff. We know this because we go to a separate bound volume that contains all copies of all of the letters. We go to a separate bound volume of General Lee's headquarters staff that contains all of these orders, and we find them all written in the hand, the same hand. And here's an example. For if you go through the letter book and you compare the handwriting to the handwriting on this document, you can discover that they're very similar. They're similar. We just don't know who the person is. Now this document, 190, is also signed by Chilton. This is the freestanding example, not the example in the letter book. This document was sent not to Cooper, as it should have been under Confederate regulations. Had it been sent to Cooper, to the War Department, Cooper is under the supervision of the Secretary of War, Randolph. And so had this document been delivered to the War Department, it meant it would have been available for Randolph to read, and Randolph read it. The entire cabinet would be aware of it. And so the government itself, the bureaucracy, the cast of characters surrounding Davis would know about it. And that is not what happened. The record is undisputable about this. General Lee wrote a letter to President Davis on September the 12th, 1862, from Hagerstown, telling him what was going on, and he enclosed Special Order 190, which is in fact the text that we know as the Lost Order, with the letter to Davis, and it was retained by Davis in his official private papers, and was disclosed in about 1945 to the general public. So at some point in time, A.P. Mason had to have access to this document 190 to copy it into Chilton's letter book at page 192, adding the text to the original two-paragraph document involving the two paragraphs that were unrelated to the Lost Order. And when he did this, how he did this, we don't know, but we know he did it. Because the syntax, the phraseology of this document in my left hand is identical to the phraseology and syntax of the document in my right hand. So they go together. There's no question about it that these three sets of documents, the original two-paragraph, the copying into Chilton's letter book, the sending of the Lost Order text to Davis from Hagerstown on September 12th, that all goes together. There's no controversy about it. It's simple. In the courtroom, and the jury, nobody can fight about it. There's nothing complex about that. That's how it happened. That's how it happened. The letter was written by General Lee. The order enclosed was written by the unknown clerk. A.P. Mason copied the text of the order that went to Davis into Chilton's letter book, and A.P. Mason, in the very beginning of the process, sent the two-paragraph order to General Cooper. So that's simple. That's simple. It doesn't tell us anything, however, about who wrote the Lost Order, does it? It doesn't. There's no clue. To that, we have to turn to these two documents. The first is a copy of the Lost Order text written indisputably in the hand of Stonewall Jackson. And the text has different syntax. Instead of using the phrase in paragraph 6 of the text we find in Chilton's letter book and we find in President Davis's papers, and intercept the retreat of the enemy, we find that syntax reads that Stonewall wrote, intercepting the retreat. So we can't say, from the record before us, despite 40 years of investigation into these facts, we can't say from what it was that Stonewall copied the text. Did he copy it from 190 before General Lee sent it to Davis? And in the copying, just as an editorial change, decided on his own when he came to that line to change the syntax from "and intercepting the retreat" to "intercepting the retreat"? Pretty, we don't know. Or did he have some other document with that text? We don't know. We don't know from what it was that Stonewall made this copy. We just know that he he added to the document the word "confidential," which does not appear on 190 or 191, the two-paragraph version, or in the letter book. He added that in his own handwriting. Then, of course, he's got down at the bottom, by command of General Lee, R.H. Chilton. But he doesn't have anything here on the other side of this footer that identifies the fact he's made this for D.H. Hill. For D.H. Hill. Commanding division. It's not there. It's empty. So all we can say about this document is that there's no question Stonewall Jackson had something available to him to copy the text that he wrote on this document in his own handwriting, labeling it Special Order 191. Now, if he used this document that went to Davis, we can't say why he changed it from 190 to 191. That's what we call fishy circumstance that we lawyers just don't like. We want to know why he did that. We don't know. We don't know. Now, we come to the document that ended up in the hands of George McClellan. We do not know who the author, who the writer is of this document. We cannot identify this person. We've eliminated everyone that should logically be the writer. General Lee, Stonewall, all the members of Lee's staff. A.L. Long is not the writer of the document, despite the silliness of Mr. Racino's calamity at Frederick suggestion. It's not Walter Taylor. It's not Charles Venable. It's not Talcott. It's not Charles Marshall. We do not know who the writer of this document is, although I'm going to offer to you a prime suspect. So, what we do know is that the writer of this document copied the text from Stonewall's copy. We know that because of that text, that syntax. Intercepting the retreat instead of "and intercepting the retreat." And intercept the retreat. The syntax of the lost order that McClellan received is exactly identical to the syntax Stonewall wrote in his copy. So, one was written from the other. Either the writer of the lost order copied it from Stonewall, or Stonewall copied it from him. But that brings us to a serious problem in the facts. It's very confusing for us. Because when we say this, we have to then ask ourselves, why did Stonewall write this copy? Why? What's the point? Now, we know that D.H. Hill tells us that at some point in time, he doesn't tell us when, at some place in time, he doesn't tell us where, He says Stonewall gave him this document, and he kept it, DHL, and it's come down to us as a result. Now, that does not make any sense. First, Stonewall does have an adjutant, and there's some confusion about the adjutant. Robert Dabney was his adjutant at 2nd Manassas, and then a guy named Paxton came in and took Dabney's place, but it's unclear whether either one of these men were actually present with Jackson's headquarters staff in the period of time September the 9th through September the 15th, 1862. It's unclear. What we do know is that Stonewall had his cousin, a guy named William Jackson, on his staff. And we do know that William Jackson, on September the 14th, at Harper's Ferry, created a special order, which I show you on the screen. And we do know that you can compare words in the September 14th special order that's written in the hand of William Jackson to the same words found in the document that reached McClellan. And it's up to you, the trier of fact, to compare the script of these two sets of words to find as a fact that it was William Jackson who is actually the writer of this document. Now, if that's true, so far in the ordinary course of events, what's the problem? Jackson gave the copy that he made to his adjutant, his cousin, said, make a copy, mark it for DHL, which means that it would be the responsibility of Jackson's headquarters staff to send this document to DHL. But instead of that happening, it went to McClellan. While the document that Jackson had to have spent at least 30 minutes of his own time writing out goes to DHL. Now, that's what we call a funny fact in the trial court, ladies and gentlemen. That just does not make any sense. First of all, he's got his cousin. If his cousin can write one, why can't he write the other? Why would a general commanding a division, in this case 3 divisions, take out of his very limited time of the day 30 minutes to write out this document when all he has to do is hand whatever it is he's copying it from to his adjutant and say, you copy it. Send it out to all the generals of division. And I've got, in this case, Jackson's got 4. He's got A.P. Hill, he's got Ewell's division, and he's got his own division under Lawton. Plus, he's claiming to have DHL under his command. So all he has to do is give a document to his adjutant, say, make copies for those 4 generals, and see that they're delivered. Instead, he intervenes, writes out a piece of paper that isn't going anywhere except to be used by the writer of this document as a copy. And instead of it going to DHL, for which it's marked for, it goes to McClellan. And no special order 191, the record shows, reached A.P. Hill, reached Ewell's division, or Lawton's division. Didn't happen. Instead, this document ends up in DHL's hands. And DHL, these guys are all intermarried. Jackson and Hill are married to sisters, Morrisons. Dabney, who was one of their original agents, he's married to another Morrison. Jackson also has a Morrison, a young man on his staff, along with his cousin, William Jackson. So this is a family affair here with this Stonewall Jackson copy. This does not make any sense. Why does this exist? Think about it when you try to come to a conclusion. And that's all we can say about. Fortunately, the jury's not in the box yet. And as you know, this is my trial book. That's all this is. This book I published, which contains a lot of stuff in here. It's my trial book. It contains all the evidence I've accumulated that I would present to a jury to support my case and to enhance my credibility as the truthful advocate, presenting them nothing but facts. I'm not hiding anything. I face the facts. I don't hide from the facts. I don't manipulate the facts. I give the jury the facts, and I help interpret them for the jury. I suggest how they can be interpreted. In this case, all I can say to them is that that's the story. This is a simple part of the case. This side over here with A.P. Hill and with Chilton, Cooper, President Davis, that's simple. Over here on this side of the equation, not so simple, because this does not make any sense. Why Stonewall wrote this document out, and why it would be him that would give it to his brother-in-law, D.H. Hill, at some unknown place at some unknown time. Not marking it. It's not marked for D.H. Hill. He didn't write it specifically for D.H. Hill. But instead of the one being marked for D.H. Hill, so something's wrong here. Something's happening here that is sleight of hand. You got to be, you got to really be objective in your thinking. You got to think it through. Does it make sense? This is what reasonable people do. The answer is no. It's not what reasonable people do. So, our prime suspect at the moment, jury's not in the box. We still have time to continue to investigate. The more time we're given, we keep investigating. Investigation never ceases. There's always additional details. If we learn those details, they can shed more light on the situation. So at the present time, after 40 years of investigation, this is the best I can say to a jury about who it is that wrote out the document that ended up in McClellan's hands. And of course, we have my adversary over here would be objecting about the admission of this document on the basis that there's no chain of custody. There's no evidence to show that this is actually the document that reached McClellan's hand. During the period of time that passed between September of 1862 and about 1920, when his son gave this material to the Library of Congress, somebody could have switched them. Somebody could have taken the original and sold them on the private market, made a copy and stuck it in place. This document lacks a foundation to be introduced into evidence. All we can say is that the executor of his McClellan's estate, a man named William Prime, wrote on the outside of a little teeny envelope into which the original document was found by the library, the words, "This is the original McClellan received at Antietam." But he's not here to be examined to tell us why he thinks that's so. How does he know? He wasn't there. So we're in trouble there. It's a mystery that only you and your people that come after you that are interested in this esoteric subject might be able to figure it out. So that's it. That's it. I would keep it. If I had the time and money, I would continue to add in additional detail to the trial book to bring it as up to date as possible to represent the case that I would present to the jury on this matter.